If you're being sued by Bankers Healthcare Group, you're going to want to watch this video. And if you're being sued by any debt collector or an original creditor, you're also going to want to watch this video, because what I'm going to do is I'm going to detail, number one, what's going on with Bankers Healthcare Group, that there's a potential class action lawsuit that is building up, and I'm going to talk about some of the problems that their clients who took out loans from Bankers Healthcare Group, the issues that they are going through with dealing with this company, and also how those same types of issues that people are experiencing with their loans that went bad with Bankers Healthcare Group, how those same issues could be going on with other companies that you're dealing with or debt collectors that you're dealing with, and how you can utilize some of those same class action allegations to either win your lawsuit that you have from an original creditor or third-party debt collector, get a very good settlement from your original creditor that is suing you, or a third-party debt collector, or just outright win, which is what the goal would be. So first, let's just kind of go over a little bit about who Bankers Healthcare Group is. They go by BHG Money. That's what I'm seeing advertised out there. And yes, I do have a client. I've had several clients that are being sued by BHG. And when I look at the court summons response, one of the things that I had noticed is that they always try to sue people for the top line amount. Now, when I say top line amount, is when they're making these loans as a promissory note, and with the promissory note, it's going to have the total amount that would be due if you were to pay the whole loan in full. And I'm starting to see this with some other companies too, where you take out a loan for $50,000. Let's just make this simple. Take out a loan for $50,000. The promissory note says $100,000. And if the loan goes bad, what they're doing is they're suing people for the $100,000 of the face value of the promissory note. And it causes a lot of confusion with people, because if they've ever had another loan that they went bad with, they don't say, well, we're going to charge you the interest on your car loan. Say you got a car loan that you didn't continue paying, they just come after you for the remaining balance. They don't try to come after you for the full amount of it, as if you were to have paid the entire note off. But this company and some of the other ones, BGH Money, and which stands for Bankers Healthcare Group, just in case you didn't know, they are doing it, and there's other companies that I'm seeing doing it. And what I think the end result of what they want to do with that is, if a person does not fight, does not respond to the court summons, that you're going to actually get a judgment against you for the full face value of the promissory note. So be very careful. So number one thing, regardless if it's an original creditor, debt collector, BHG Money, whoever, you're gonna want to make sure that you respond to the court summons, because you can get a default judgment by not simply following the instructions to respond within the 20 or 30 days, depending on where you live at. So you have to do that. You must respond. All of those are allegations against you, and if you don't respond, you're going to get a default judgment against you. Some of the times, even if you show up to court and you don't have a response, that you will still get a default judgment. That's, depending on your court, but I've had people say, hey, I showed up and I still got it wasn't technically a default judgment, but they got a judgment because they had no response to the court summons. At minimum, when you respond to the court summons, at least you can buy yourself some time and be able to consult with someone to see what could be your best options moving forward. So if you're new to my channel, or you're a long-time subscriber to my channel, you know that I cut my teeth, and they always use that expression, cut my teeth, on a video that I made years ago on Santander Consumer Financial. And Santander Consumer Financial, what they were doing is they were making subprime loans to subprime automobile loans. and they ended up getting sued in a class action lawsuit, 36 states. And even people who were not within the 36 states, from watching my videos and taking the information that I had put out there about the class action, they were able to renegotiate, very good settlements on getting their vehicle. One that comes to mind is a young lady used information from my YouTube video to get a $13,000 balance taken down to $1,300, and she got the title to her vehicle. All because of the class action issues. So you may not even be aware of the things that are going on. Maybe you have a loan with BHG and you haven't paid it, and you're just waiting for them to drop the hammer to sue you in court. These are some of the things that you need to watch out for. And if you don't have a loan with them, but you have loans with other companies, these are some of the things that you can watch out for to either put yourself in a very good negotiating position or to potentially win your case. Because right now, what I've found is that BHG Money has a class action lawsuit building up. So right now, as we speak, it is building up. There's law firms that are asking for clients who have gotten loans from this company and they went bad, and even business owners who've gotten loans and they didn't go bad. They want to review it to see if some of these issues were with their loans. And it's not all about the contract on the loan. Some of the stuff is about the way that they approach people for these loans. So now, let me just tell you what BHG says on their website. They say that they give loans for personal loans for looks like for debt consolidation, which I did not know that they do. They have existing business loans and they have new business loans that they make. Now, I'm not against any company loaning out money to people because, we need money to be able to build our business. There's different ways of doing it. This company allows people the opportunity to do it. What I am against is getting a business loan for all the wrong reasons. I don't want to point any fingers to people, but what I've seen happen is that a lot of people were directed at certain companies for business opportunities that were not legit, that they were not going to work. Because I'm pretty sure if someone was to be able to get the money for their business and they were able to utilize that money to grow their business or to start their business and they have a legitimate business set up, there wouldn't be any of these issues. But when there become issues, they start to look at, because of the number of issues with people not paying and people getting sued, attorneys start to look at the way that people were presented these loans. And just like we had, even though this is on a different level or different topic, same issues that we had with the housing crisis back in 2008. These companies are throwing out money and they're not really checking out to see if people are legitimately either in business or that their business is going to be able to sustain the money that's coming in. It's just like they're just trying to push the loans out on people. So let's talk about some of the issues that I found that they're utilizing for the class action. Let me get back to my page that I have on that. Okay, so we're going to talk about some of the issues in their class action. And keep in mind that if you're being sued by any company, it doesn't matter, original creditor or debt collector, you can always go to our website, thecreditrepairshop.com, submit your question on the live chat, and if you want to kind of expedite things, upload a copy of your summons. Upload a copy of your summons, and we can review it and let you know how we can help. All right, so some of the things that are going on that I've read in the class action, what they're looking at is that they're saying that there's that Bankers Health could potentially, these are allegations, they haven't been proven, but they're saying that they're breaking certain truth in lending laws or misleading. The people who are taking out the loans are misleading them with certain information about the cost of the loan. And remember what I stated in the lawsuits that I have personally reviewed that they have that issue with the promissory note. So if the loan goes bad, they had the promissory note amount on there that they're trying to go after people for. But also there seems to be some issues with the truth in lending, and I believe that stems from when people look at the amount that they're taking out and they look at the amount that they're going to be paying back. I'm just here to tell you, it's the same amount that the amount in interest that people are paying in these loans is the same amount or even more than what they borrowed. On one of the contracts that I looked at, it makes it look like the interest rate is higher than what they've have actually put on the truth in lending statement, because you're like, why is it so high? But actually the reason why it's so high is because they're extending out the period of time that you're paying the loan back. And then the next thing that they're talking about, a lot of that they're doing with a lot of people, and this stems from people signing up with these different business opportunities and stuff like that, is that people are actually W-2 employees and that they're not actually a business owner. And that some of the people that they're claiming in the allegations that they really never took the steps to start a business. So I don't know how that's gonna play out, but they're actually saying that because when these lending institutions, they have a responsibility, if it's a business loan, that they need to have checked all the boxes that it's actually a business loan. Even if you're giving a loan for a business that's starting, they should have checked all the boxes to show that this business is going to be one that's starting. Another one is the excessive origination fees and interest rates without providing certain disclosures required by law, and penalized or outright prohibited consumer prepayment in order to maximize interest accrual. So they're stating in there that the interest that they took, they had I haven't seen a loan that had anything about a prepayment penalty. That seems like that had went away, but in some of the loans, in the ones that I've reviewed, they did not have a prepayment penalty in there. They did have the high interest rate over a period of time. Not a high interest rate, but over a period of time for the longevity of the loan. It was a long period of time. I think 84 months on one of the ones that I reviewed. And but I did not see any that talked about having a prepayment penalty. The next one here is they charged interest and undispersed funds and secured their loans with all of the borrowers' property as collateral without providing the requisite disclosure and consumer protections for such an agreement. So, that is what it is, what they're saying. So I'll read it again. They charge interest on undispersed funds and secured their loans with all of the borrowers' property as collateral without providing the requisite disclosures and consumer protections for such an agreement. Next, they insert false commercial and sole proprietor language into their loan documents sent to the consumer to fraudulently disguise consumer credit transactions as commercial credit transactions. The next thing that they have in the potential class action, they disguise consumer lending as commercial lending in order to evade federal and state regulatory scrutiny and to increase their own profits at the expense of unsuspecting consumers. Number 7, they start the solicitation process by offering fast funding in large amounts from either BHG or PB, which is the other name that they go under. And then they misled consumers to believe that loans will not require collateral or affect a borrower's credit score, which is not true, because in most of these loans they're utilizing the credit score of the individual, but they're putting it in the business's name. Next thing, and I've seen that where it's a crazy thing, because you have a personal guarantee. So they had to utilize your credit, because how can they, have a personal guarantee without utilizing your credit in the process? But on the credit reports, they do not state the individual, on their individual credit reports, that they have this loan. But they're coming after the individual for the personal guarantee. And from the ones that I've seen, even though they're going after the individual for the personal guarantee, they still have not put it on their loan on their credit reports when the loan went bad. But they're suing the individual in court in the business name and in the individual's name, and there's a big reason on why they do that, because what they want to eventually do is to have that in the individual's name, and then they want to map that over to whatever state you live in if you don't live in the state that they sue you in, and you're going to have a default judgment against you because you don't have the money to get representation in the state where they're at. There are remedies for that. So go to my website. I'm not even going to talk about that on here because I don't want to always show our hand. I don't want to show our hand, period, on what we would be doing to counteract that. The next thing we got here is they have their salespeople usually fill out most or all of the loan application for the borrower and routinely persuade them to click through the online paperwork, which relies heavily on legalese, while the salesperson remains on the phone with the borrower. And even where voice questions or concerns about certain terms in the company's loan documents, BHG personnel are trained to orally explain away predatory terms as inconspicuous and then earning the consumer's trust. So they let me just repeat it. BHG personnel are trained to orally explain away predatory terms as innocuous, and then earning the consumer's trust with interpersonal charisma and apparent professional knowledge. As a result, borrowers remain in the dark about the lender's expense and punitive financial terms, until well after the transaction is executed. Sorry about that. The person who wrote this did not write it in a way that I would have wrote it. But basically what they're saying is that when people had felt that something was wrong with the loan, whoever their salesperson was on the phone or their customer service representative, that they are actually trained to kind of pull down those fears and to kind of push the person along. Probably said things like, don't you need the money? Think about what you're going to be able to utilize the money for your business. Don't worry about this, just a small print. And then the person ended up signing for it. And then well after the transaction was executed, they were like, man, I've gotten myself into a bad deal. So I'm just telling you what they are starting to put together for the class action. This is what they're starting to put together. This sounds similar to what happened with Santander, because in Santander, what happened was the finance department for the car dealers, they were kind of doing something similar, and that's on record. So this is allegations with BHG. You can always go back and look at Santander to see what they were doing, so you can see, because that's on record. If you're getting sued by an original creditor or debt collector, we want to review your court summons, and we will give you some options on how we've been able to help other clients who are being sued by either third-party debt collectors or original creditors. If you're being sued by BHG, I'd be happy to look at your court summons and give you some options on what you could potentially do. We've been able to help a lot of people with their court summons complaints with the response, because you are required to respond to that court summons regardless if you owe the debt or not. It is a requirement by the court. You can read the documents that they give you that state that you have to respond to that court summons, and if you don't respond to it, you could potentially get a default judgment, or if you go into court and you haven't responded, you can get an automatic judgment. This is something that once the court requests that you do it, that you have to have some sort of response for it. We've been able to help our clients outright win their third-party debt collector lawsuits. We've helped clients win original creditor lawsuits that had issues. We've had clients be able to get a very good settlement, either with a debt collector or with their original creditor. It's going to be different for every case. Your situation is going to be different. The most important thing is that you don't have to feel like you don't have any options. Don't have to feel like you don't have nowhere to go. We're here to help you and at least get you the information so you can be able to make some educated decisions on being able to move forward if you're being sued by a third-party debt collector or an original creditor. So if you need help, please go to my website, thecreditrepairshop.com, and there's a link on there. You can hit the live chat. You can upload your court summons and also kind of tell us what your goals are. If you're looking at fighting the case or if you would just like to move forward to get the case settled. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, yourorder3scores.com, to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. Everything starts there. If you have debt collectors coming after you, grab my 3-pack of letters, statute of limitations, debt validation, and cease and desist collection activities letter. These 3 letters are very important because you can stop debt collectors before it gets to the point to where they sue you in court, or it could help you get information that they may not want to reveal unless you ended up going into a full-blown trial with them in court. And just to give you a quick example to kind of tell you what they might reveal is that they don't have the original contract, or that they may not have the bill of sale from the original creditor when dealing with a third-party debt collector. So these letters are very important. And in the statute of limitations letter, you might be getting sued by a debt collector when they're not supposed to do that. We just had a young lady that's getting sued by a debt collector that is not even supposed to be suing her because the debt is past the legal statute of limitations to collect. So you need to get those at minimum, just so you're just not out there just, not responding. Because I know there's a lot of videos out there telling people not to respond, but if you respond, I call it being proactive instead of being reactive. Whenever you're proactive, good things can happen. So thank you for your time. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.